Hello, everybody. Good evening. Welcome to the Debt Hotline. My name is Hannah Locklear. I am a part of Team Solo. And at Solo, we help people respond to debt collection lawsuits and settle their debts before court or after court at any stage of the process. So, we're really excited for tonight's episode of the Debt Hotline. We have a really exciting guest joining, and our topic for the night is what to expect if you're sued for debt. And we actually have a real lawyer joining us tonight who's going to share some of his experience regarding debt collection lawsuits, debt litigation in general. And I wanted to take a minute to introduce him. But before I get into that, I also wanted to say that although, our guest tonight is an attorney, please don't take any of the information that we share tonight as legal advice. We do not represent you in your case if you are being sued, so please don't take this as legal advice. This is strictly educational information and resources to help point people in the right direction. So with that being said, I wanted to take a moment to introduce our guest. His name is Mitchell Ortega. Mitchell is the Director of Litigation at Guardian Litigation Group, where he leads the firm's collections litigation practice and assists with creditor harassment and bankruptcy cases. He was born and raised in Florida. Is that right, Mitchell?
Yes, that is correct.
In Broward County. Did I say that right?
Yep, Broward County, right outside Fort Lauderdale.
Perfect. So born and raised in Florida, and he began his career in legal aid, helping indigent clients with Social Security, domestic violence, and landlord-tenant disputes before he moved into commercial litigation and consumer protection law. He has a lot of experience with the Fair Debt Collection Practices Act, collections defense, and bankruptcy, and he has dedicated his career to protecting vulnerable individuals and leveling the playing field for consumers in debt-related cases. And he's also founded Guardian Litigation's community pro bono initiative, which encourages attorneys to give back through voluntary service. So super duper great resume and lots of very relevant experience for tonight's topic. And for anybody who is watching live, you can go ahead and start submitting your questions in the live chat. We'll be getting to those questions here in a minute. But before we do that, I wanted to give Mitchell a minute to fill in any gaps that I might have missed when I introduced you and tell us a little bit more about what you do and Guardian Litigation Group.
Well, Hannah, thank you so much for letting me join you this evening. I am a huge fan of Solo and the empowerment it offers to individuals around the country who are dealing with these situations. I have the pleasure of working at a law firm called Guardian Litigation Group. We are a consumer protection law firm. We operate in most jurisdictions around the country, and I have the unique pleasure of being able to help people traverse a very difficult time that they may experience when these lawsuits happen or they're dealing with debt in general. We all know it's never a pleasant experience. I'm sure most of the people listening tonight may have some experience or are about to go through some experience. A couple of things I wanted to say right from the start. There is always a lot of stress and anxiety associated with dealing with these situations. And the fact that you're watching tonight and learning more and educating yourself, I could not commend you all more for trying to get better educated, because this is how you get past that anxiety. This is how you get past that stress. Preparation is key. Education is paramount, and this is exactly the thing you should be doing when you're going through a situation you've never been through before. I think that there is a common misnomer when it comes to these types of lawsuits that people who are being sued for the collection of a debt just went on Amazon and ordered a bunch of things that they couldn't pay for, or splurged on a car. But in fact, most of my clients are people that have just gone through difficult situations, people that have lost jobs, people that have lost loved ones, people that are dealing with medical situations. I'm a Floridian. My entire life, I've had clients that have had hurricanes knock off their roof and have had to live with a tarp over their head for months, if not years at a time. These are situations that you really can't avoid or prepare for. It's just life sometimes throws you a curveball, and so I don't want there to be any sort of shame or embarrassment when you're dealing with this type of situation is very important. I usually have these conversations with clients right from the start to empower yourself. Let's talk about it. Let's just get right into it and deal with these types of situations. But I'm very lucky to work at this law firm. I have an amazing job. I get to help people, so I love my job. But yes, Hannah, that was a very good introduction, and as far as my background, that was pretty much up to speed.
Perfect. I love it. And I want to echo what you said about, feeling shame because you're facing debt. I think most people take out debt with the intention of paying it back. And life happens, and there's a lot of things that are out of our control. And so there shouldn't be so much stigma surrounding this topic. And I'm really glad that you're here tonight. Hopefully, we can break down some of that stigma and just talk about things openly. And, again, for anyone who's listening live, please go ahead and submit your questions. We actually received a lot of questions submitted to the Debt Hotline beforehand. And our goal is really to just educate and help people. So thank you so much, Mitchell, for pointing that out. I think that's really important. That being said, before we jump into some of those real questions from real people, I did want to ask you a few preliminary questions about tonight's topic, which again, it's what should you expect if you've been sued? So for someone who has been sued by a debt collector or maybe a creditor because they owe money, what is the typical process like and what can they expect?
So generally, most people find out that they're being sued by receiving a demand letter. This might happen well before a lawsuit is ever filed with the court. You'll get some sort of letter in the mail from a law firm or even the creditor themselves stating that they intend to take you to court. Usually, a big indicator that it's going to go to litigation is if that letter does come from a law firm. And if you Google this law firm and find out that they are in the business of collecting debts and filing debt lawsuits, more than likely it's going to be happening very, very soon. Those demand letters do offer you a good opportunity to preliminarily try to be proactive, whether that's coming to solo, whether that's retaining counsel and going to an attorney. And I just want to reassure everyone that when you get those letters, is it a guarantee the lawsuit's coming? No, it's not a guarantee, but more likely than not, that's probably what's coming down the pipe. After the lawsuit is actually filed with the court, you will be served with process. And this is probably the most significant event, especially relating back to what we were talking about of shame and embarrassment and anxiety. When I talk to clients who've been served with a lawsuit, or just being sued in general, this is the one event that really sticks out to them because a lot of them have never been to court before. They've never even been to jury duty. It's a very new experience for them. And when you have a process server or sheriff show up at your door, you could have a neighbor walking their dog right across the street. You could have a very close knit neighborhood where you know everybody and everybody knows you, and you have somebody show up at your door and serve with the lawsuit. That's a very tough situation to go through. But just keep in mind that that is part of the process for having the court have what's called jurisdiction over you. It's a requirement. And keep in mind also later on that if you were not served properly, that actually is a defense that you can raise in court. It's going to be state dependent on what the requirements are for service. There's different rules all over the country in the various states that you all live. But that is a tough spot to be in especially if you've never experienced that before. What I do tell clients, because a lot of people do feel this way, do not avoid service, do not evade service. If they knock on your door, it's best to just take it because they will come back. They will stay out there all night. They will ring your doorbell. They will make a big deal out of it. This is their job. And if you're not trying to draw attention to it, you will by evading it. The other risk, though, is if you evade service, this could be something that the court and judge get angry about at a later time. So I have clients that are like, I don't know if I want to take these documents. And when you know it's you that's being served and they're asking for you, I find it's best usually just to take it if you find yourself in that situation. There are other things that an attorney might be able to do before service, but as far as accepting service on your behalf, but that's a discussion you can have with your attorney. Those documents that you receive are usually going to be a statement of claim or complaint. It's the official document that starts the lawsuit. That is going to give you notice of what you're being sued for. It will have documents attached to it, potentially in support of the claims of the creditor that's suing you. And most importantly, for the sake of this conversation, And if you all take anything away from this evening, I want you to be aware that if there is a court date set inside that document, if it says you need to be in court at a certain date and time, I don't want you to just be there. I want you to be there early. The most important thing that you possibly can do is show up if you're required to do so. One of the most it's becoming more well known, but one of the most staggering statistics when it comes to these types of lawsuits is how many of them end in a default judgment, which means that no one defended themselves. And that's how the creditor won their case because you didn't show up. As much as it might be stressful, as much as anxiety as it might give you to go to court, that is 10 times better than giving the creditor an easy win of the case. And now the presumption is that the debt is valid. You just waived all of your defenses. You put yourself in a very, very difficult spot if you do not at least even show up to court when the documents instruct you to do so. And I think that I saw, Hannah, a lot of the questions that were already previously received are going to get into some aspects of the case after that first court date. So I'd rather just start diving into some of these questions because I know some of the blanks I'm leaving here are going to be filled in as we go through some of these questions.
Love it. I think that's a great plan. I do want to reiterate what you said, though. Like, it's super duper important not to ignore a debt lawsuit. That's probably the worst choice that you can make, even though it is stressful and intimidating. And the thought of, dealing with all the legal aspects and going to court might be scary. That's the last thing that you want to do because it most likely would end in a default judgment, which could lead to wage garnishment, seizure of your property and assets, and just make the whole situation much worse. You could end up actually paying way more than you originally owed in post-judgment interest. It's just not a good idea to ignore it. So if you have been sued for debt, be sure to file an answer. Solo Suit can help you file an answer. If you go to solosuit.com, we've got a tool that can help you draft and file your answer and at least just get that default judgment blocked. And then Guardian Litigation Group also can help represent people who maybe have like complicated or big dollar cases or whatnot. I know you guys take on all types of cases, but just know that there are resources out there. So with that being said, we'll jump into some real questions then. So our first question comes from Alexandria in Georgia. Alexandria says, I have 3 lawsuits that have been presented to me more than 3 months ago, and I have filed the answers. I have yet to hear about a court hearing date. The county court website shows no updates to the case. Does that mean that the judge hasn't had a chance to review them yet? And if so, does that still mean I have a chance to potentially settle them beforehand?
Yes, so that is kind of correct. A lot of and I know we have a lot of attorneys that are law firm that practice in Georgia, and I know there's a lot of courts there that have a lot of traffic and they're backed up significantly. So I just want to reassure Alexandria that it's not uncommon that she didn't do anything wrong as long as the answers are reflected on the docket. She is not ripe to have a default judgment entered against her, and she should still keep an eye out for any other updates that might come from the court in the mail. But no, it is not uncommon for something like this to happen. The case is just going to sit there until one of the judicial staff members or the clerk of court or judicial assistants catches wind that the case is just sitting there and needs to be moved forward. As a reminder, and I think this is important for Alexandra to understand, the burden of moving a case forward is not on you. So it's not that you are required to do something that you're not doing at this point in time. It's the plaintiff or the creditor's obligation to move the case forward. Nevertheless, what's right now, what it's called as far as the phase is the discovery phase. After you've answered the lawsuit, hopefully either you use solo or if you retain an attorney, or maybe you drafted one yourself after doing some research that you have drafted an answer that has some affirmative defenses that will state, why you should not be liable for the debt you're being sued for. After you filed that, technically speaking, at this point, the creditor and you are allowed to make formal requests for information to each other. This is extremely common in litigation in general, and especially in our lawsuits. This could be these debt lawsuits. It's an opportunity for you to potentially ask the creditor to provide you more documentation substantiating the claim that they're making that you owe this money. So you can ask them, for instance, if it's a claim based upon a contract, you can ask them for a copy of the contract. If it's a claim called an account stated, which is a very common cause of action you see in these cases, you might want to request for more account statements showing that that you actually did accumulate the debt that they're seeking. You could ask for any preliminary communications that were made between you and the creditor prior to the lawsuit or even after the lawsuit started. That's the phase you're in right now. But to answer your question directly, yes, you are still able right now to reach out, start settlement discussions. I was gonna save these for the end, but I do want to let you know, Alexandra, when you're having these discussions with a creditor, there are a couple of things I want you to keep in mind. I want you to do all communications in writing. You could talk to them on the phone, but you still at least want to confirm everything in an email that you could send to the creditor's attorney after you're done. And also, if you do agree to a settlement, do not pay anything until you get that in writing as well. It's very, very important you have a written record. I'm not saying that creditors are trying to take advantage of the situation. Mistakes happen. We're all human beings at the end of the day. I have seen settlements that were supposed to be X, Y, and Z end up being A, B, and C, and it's not what you agreed to. So always try to get everything in writing beforehand. But right now is a great opportunity for you to try to at least get a handle on at least one of the three cases that you find yourself in.
I love that. Yeah, I think that I don't know. I think that one thing that we try to emphasize at Solo, and after looking at data of over 300,000 users who have used Solo to respond to lawsuits, is that oftentimes in cases like this, like settling is in many cases the best outcome for you, um, unless obviously like the debt is fraudulent or invalid for whatever reason. But settlement is really a good way to kind of resolve the lawsuit. And so if you can negotiate beforehand, before the court date, that could be a good idea. But just make sure that you go into those negotiations prepared. And at Solo, we also have a tool called Solo Settle, where you can negotiate with creditors and collectors online and try to settle outside of the court process. Which, Mitchell, would you say that like it's might be in some cases easier to settle before the court date, just because it takes resources and time and money for attorneys to show up in court? Do you think that many like attorneys that are doing the suing would prefer to settle before the court date?
Absolutely, and not only would they prefer to do it, it's more advantageous for the debtor a lot of times too. There are lawsuits, it's depending on the debt itself, but there are lawsuits that are also seeking things like attorney's fees. They might be seeking interest on the debt, which means the clock is running. And every day that goes by, the debt gets higher and higher. And if they're seeking attorney's fees, everything that the attorney for the creditor does, they're going to add on to the costs of the settlement. So if you try to settle with a creditor's attorney after a hearing, they might now raise the offers they're willing to give you because they had to pay their own bill or the creditor has to pay their bill. Somebody's getting paid over there. So you'd rather do it beforehand and avoid inflated costs of settlement. But also I will tell you because I know a lot of them, and I don't want the conversation this evening to shed any negative light on attorneys that do represent creditors. They're doing a job. They have an ethical obligation to represent their clients in their best interest. They're human beings also, and they're very overworked. I happen to know a lot of colleagues over there. They have a lot of cases. So the fact that you might have a conversation, a substantive conversation about resolving the matter in totality prior to a hearing, that's something that's very appealing to them. And they might be willing to work with you a little bit more if you try to engage in those conversations beforehand. And at minimum, even if you're not able to resolve, at least you know what universe you're working in for settlement, so that if you end up going to court and you try to negotiate more while you're in the courtroom or at an informal mediation or formal mediation in front of a judge, you'll already have a head start on knowing what the offers have been. And now you can gauge the offers you're getting in court versus the offers you've received previously. So at minimum, it's like getting some reconnaissance done and knowing what the creditor is willing to offer. So yes, to answer your questions, a lot of different reasons why it's advantageous to try before trial or a hearing to try to get the matter resolved.
And we've seen in our cases, or like in our experience, that a lot of the times, right after you file your initial answer, is a really good time to reach out and try to like that. That might be a good time that gives you more leverage to negotiate and talk about your options with the opposing attorney. And in most cases, if you're representing yourself, you would contact the opposing attorney to negotiate instead of reaching out to like the collector or the debt buyer or the creditor that the attorney is representing, correct?
That is absolutely correct. And one of the reasons why that is something we've already discussed, which is if you've answered the lawsuit, that means it's not a default judgment, which, the creditors like to eat up like candy. It's like music to their ears every time a debtor does not show up to a hearing and they request a default judgment, and now they got that judgment in their pocket. So as soon as you file that answer, you're now moved in a separate stack of paper. And you're basically at this point just a headache for the creditor because now they're like, oh boy, I got to move this case forward. If we got to go to discovery, we got to go file motions, we got to go to trial. Let's just try to get this matter resolved because I have 50,000 other cases behind this one that I need to get to as well. Use that to your advantage. Absolutely use that to your advantage.
Perfect. I love it. Well, let's jump on to a next question. This one is about default judgment. This question comes from Antonio in Utah. He says, what can they do after a default judgment if you have no assets and your only income is from disability?
So this question is very state law specific. I only practice in the state of Florida. I can tell you that using the state of Florida as a comparison, judgments in the state of Florida are good for up to 20 years. So just because a judgment doesn't look like it can be collected right now because you have no assets, you have no income that can be garnished, you have nothing else that's really that a creditor can execute on using the judgment doesn't mean that in 5 years or 10 years or 15 years down the line, and believe it, I believe me, I have seen these lawsuits. I have seen and defended individuals who were sued in 2008 and had a default judgment entered against them and they just forgot about it and the creditor just showed up last year and they're now trying to garnish wages, and the clients, they come to me and they ask me what can they do about it, and unfortunately the answer is really not much, because this is the danger of a judgment. The presumption is the debt is valid, even if it was identity theft, even if it was fraud. The time to raise those issues are during the initial lawsuit, not after a judgment is entered. So, getting back to this question, probably not much is what I would say the creditor might be able to do. But keep in mind that judgment is still going to gain interest over time. The state of Utah sets an interest rate that accumulates on civil judgments. So it might be $5,000 today, but it could be $7,000 in a few years. So keep in mind that that amount will grow. And there's also credit reporting as well. If that's something that's important to you, a judgment, although the judgment itself might not be reflected on the credit, that is significant for credit reporting purposes. It could adversely affect your credit as well. So it sounds like you have a lot of protections, Antonio, but these are just things to keep in mind, that just because you might be what people refer to as judgment proof right now doesn't mean you might not have assets in the future, that might be something the creditor can try to execute on.
Yeah, I would also add, if there is a default judgment in your case, filing a motion to set aside judgment or vacate judgment could be a good way to kind of reopen the case and maybe see what your options are to settle the case. Um, but but again, like Mitchell was saying, it sounds like in some states you might be protected from garnishment. But again, if you have any assets or like a home or anything, that might not be protected.
And I just want to add real quick to that point. And this is from what I've seen very true from all states around the country. For a motion to set aside, or for the purpose of this conversation, to take away or erase a default judgment, when you file a motion like that in court, the time between the entry of the judgment and the time you file that motion is one of the factors the judges will look at to determine whether to grant that motion. So if you file it 10 days after the judgment, judges are more likely than not going to, it's going to be a good chance it might be granted. But if this happens 3 or 4 years down the line and you're trying to set aside a judgment, unless you've got a rock solid argument or grounds, chances are the judge is not going to be too warm and fuzzy to the idea of setting aside a judgment that's stale.
That's super helpful to know, yeah. So it's best to try to submit that motion to set aside or vacate the judgment, within, a couple weeks of the judgment being entered.
Ideally, yes.
Perfect. Okay. Well, let's move on to a few audio questions that we received. We had some people call in and leave voicemails. So I wanted to share some of those questions. They're definitely relevant to your area of practice, Mitchell. So I'm going to go ahead and share a question from Susie right now. And let me know if there's any issues with the audio, but here we go.
Hi, I am submitting a question for the live. So I am being sued for debt in Texas by Wells Fargo. I did respond to it, so I did give an answer, and I submitted a motion to compel arbitration based off of our credit card agreement. A court date has now been set here in Texas, and so I am looking to see what are my next steps as far as just bringing things to show my reason for motioning to compel arbitration or anything else that I need to be prepared for at that court date. Yeah, that's all I got. Thank you.
Okay, so Susie, I think that you actually did a good job of answering your own question in the question you provided, which is that the arbitration provision is found in the very contract that you agreed to with Wells Fargo. When Wells Fargo sued you, more likely than not, they acknowledge the existence of that contract. Unless there was some sort of waiver of the arbitration provision, you just need to really bring that contract in there. Maybe it was attached to Wells Fargo lawsuit. Hopefully you have a copy of it. And if you don't have a copy of it and you go to that hearing, you might be able to ask the judge for time to request a copy of it from Wells Fargo. Nevertheless, arbitration and arbitration provisions are really a creature of contract. It is something that is agreed to when you enter into a contract with another party. A lot of times banks like Wells Fargo, who we litigate against all the time, they put those provisions in there to protect themselves. I love the idea of consumers turning tables and making the arbitration claim yourself and compelling arbitration that way. A lot of times as well, you do not have to pay the costs of arbitration, depending on which forum is found in the arbitration provision, which is something I'd like you to look into. It might be JAMS, it might be AAA. These are names of organizations that are usually found in the arbitration provisions that you'll be in front of, but they all have rules, these organizations, on who actually pays the cost of filing the arbitration. So it's possible that Wells Fargo is going to have to foot the bill now in order to go to arbitration. But to answer your question directly, you really just want that contract. That's really what you want to bring into court with you to show that there is a valid arbitration provision.
Perfect. Okay, we've got another audio question. This one comes from Corey. I'm going to go ahead and share my screen for that as well. All right, this question's a little bit longer, but here we go.
Hi, my name is Corey. I was recently sued by Zwicker and Associates via American Express for approximately $22,000, from which I was able to negotiate a settlement agreement with Zwicker and Associates through their call center for approximately 55% of that original amount, thanks in part through Solo and their resources on their website. Coming into the pretrial conference, I was able to demonstrate that that settlement agreement had been reached, at which point the plaintiff confirmed. And since then, had another basically Zoom meeting with the judge and the plaintiff. Plaintiff claimed that he had sent me a consent judgment, or what's also referred to as a stipulated order of judgment. I had not received it at that time, but he basically within that meeting said, hey, all you need to do is sign this, and then we would move forward to dismiss that. I since received the stipulated order of judgment, and within that, the plaintiff has this written: defendant is indebted to the plaintiff in the amount of that amount that was due, plus court costs consisting of a filing fee in the amount of $160 and a service fee of $55. And then it goes on to basically state what the agreement was. So my question is I was under the impression that the plaintiff in this case, being that they brought the complaint, that any sort of filing fees or this quote unquote service fee is on them and not me to pay. I just wanted to confirm that. If in the grand scheme of things, I need to pay the fee and sign that consent judgment as is and get it back to them, that's fine. I was just curious about that and I thought you could help. Thanks for your time.
Wow. All right. Fantastic question there. A lot of things going on here. First of all, Zwicker and Associates, if you are listening to this and you've been sued, I'd say it's a 50-50 shot. They're the law firm that's suing you. They're probably the most prolific filer of unsecured debt lawsuits across the country. 55% is a spectacular settlement on an Amex with Zwicker, so great job there. As far as the question that the gentleman asks, and I just want to maybe repeat this in a way that's a little bit easier to understand for those listening right now. He agreed to a settlement. The settlement was reduced to a writing. He referred to it as a stipulated order of judgment. We sometimes just call them STIPs. And the stipulation, and it's very common for a lot of other law firms as well, the stipulation said right at the top that this gentleman was indebted to Amex through Zwicker for the full amount that he was being sued for, plus court costs, including the filing fee and most likely the service of process fee as well. And he was asking, isn't that something that they're responsible for? And is it uncommon for that type of language to be found in that type of agreement? So the answer is it is common to have that language in the STIP. The stipulation itself is a formality that needs to be provided to the court. And American Express, when they agree to a settlement, they want protection themselves just in case you agree to make a payment that you don't. They want to be able to say, okay, we agreed to a settlement. You didn't pay the settlement. Now I can go back to the judge and tell the judge you didn't pay the settlement and I want the full amount that I was suing you for, plus those court costs, the filing fee and the service of process fee. That language is there to protect American Express should you default on your agreement. However, he went on to say that the terms of the settlement, that 55% settlement, is found inside that STIP. And as long as the gentleman makes those payments, those court costs and service fees are not going to be a part of the settlement that he's paying. So that issue is only implicated should he breach the agreement. Other than that, I think he did a fantastic job. 55% on an Amex debt is a really good settlement. So very good for you. But I don't want you to be concerned about that language. That is very commonly found in stipulations.
Thank you so much, Mitchell. Very helpful answer, and very hopeful. And also congrats to Corey, 55% settlement with Amex debt. Yeah, I would say that's a huge win.
Great job.
Congrats.
Great job.
Okay, well, we've got some questions coming in on the live chat for those who are watching live right now. We're going to go ahead and queue some of those up if that's all right. Let's go ahead and get started with Alec Bailey. Alec's question is, can you share any insight around the process once a civil collection suit is filed against you? Do I first need to provide a formal response to the court before any of the debt is paid? So we've kind of touched on this topic a little bit, but Mitchell, what would you say?
So it depends on the procedure of the particular state that you're in. Generally, the answer is no, though. You do not actually have to show up in court or file a response to the lawsuit in order to settle the debt and start payments on the settlement. But I would just reiterate something I said earlier. You want to make sure that the settlement is reduced to a writing, that you have something to prove that you actually did agree to it. And a lot of times, even if there is a hearing, you could just produce that agreement and the court will dismiss the case and retain jurisdiction to enforce the settlement agreement should be breached, which is a fancy way of saying that the court acknowledges the settlement and just leave me alone unless you need me to deal with some other issue. So the answer there would be no.
Perfect. Okay, next question comes from Tia Joe from the live chat. Tia says, I won arbitration against LVNV in Arizona. They are appealing the arbitrator's decision and requesting a new trial. Is it likely the court will grant them a new trial? If yes, what can I do?
Well, fantastic job. It's always fun to win at arbitration. This is a very tough question to answer without more facts and more background about what happened at the arbitration that gave rise to the award being in your favor. If it was a matter that they maybe miscalendared the arbitration date, or there was some sort of procedural or notice issue that precluded them from actually being able to participate in the arbitration, it's more likely than not, assuming this motion was timely, that the judge might agree to give them a new shot here. But there's also going to be issues here with Nevada state law that might be implicated, and I don't want to bite off more than I can chew. It's very, very hard ever to predict what a judge is going to do. There is never a sure thing in litigation. Sometimes judges are just in a bad mood and they rule a certain way, and there's nothing that you really are able to do about it. I'm not trying to bemoan the judiciary whatsoever, but for the sake of trying to predict what a judge is going to do, very, very difficult. Very, very difficult. The only things that you can do is consider the facts that are in their motion. And if they misstated something, if they're misrepresenting something, that is something that you want to bring to light to the judge before the judge makes a decision on whether to grant a new trial.
So, can you tell us a little bit more about like arbitration and what people can expect when they go to arbitration?
Sure. Arbitration, the most common example I like to use is anyone who's ever watched Judge Judy or any of these daytime TV shows where a TV judge will hear the case between two parties and make a decision. Usually, that is a form of arbitration. The parties before they went on TV, just like a regular arbitration, agreed to have their matter heard by a private party, an arbitrator, and everything is done more in private. Everything is done with a little bit more it's much more expedient. It's much more quick. Litigation, like for instance, the question you received earlier about Georgia, where we had somebody file 3 answers and the cases have been sitting there for 3 months. Litigation could take a long time. It could be very, very expensive. Arbitration is usually something that's appealing if you just want to know what's going on and let's just get it done with real quick. So there's a lot of advantages and disadvantages depending on your situation. But arbitration, what you can expect is like going to trial. You're going to have everything decided and presented the same day. The arbitrator is going to make his decision. In certain states, there's procedures from trying to do what with the question we just received, which is appeal the arbitration or seek a new trial based off the arbitration. But like I mentioned as well, the arbitrator is going to belong to an organization. The two most common I mentioned were JAMS and AAA. They're also going to have their own rules there. They might adopt the rules of evidence of your jurisdiction. They might not. There's a lot of speciality and nuance to arbitration. That's a situation in which I think it might be best to potentially go speak with an attorney and maybe get a little bit of an idea of what to expect because it's very forum and state specific.
Perfect. And I do think it's interesting that, arbitration, trial, hearings, court, those are questions that we get a lot at Solo. Like people want to know what to expect when they go to court. Because I think that's like kind of the most intimidating part, especially for someone who's representing themselves. We have a few other questions kind of related to this. One comes from Annalisa in California. She says, I received the notice of hearing, which is dated April 28th of next year. So like more than 6 months out. Do I have to wait for that date or can I take care of it earlier? What is the next step? And Mitchell, to your point, you had mentioned that it's not uncommon for courts to get overrun and for litigation to take a really long time. We've seen cases in California where the defendant will file an answer and then their court hearing doesn't get scheduled until like a year later. And so sometimes it really just is a waiting game because of how busy the courts get, right? So I think arbitration or negotiating outside of the court setting can be really great options. But what would you have to say to Annalisa? Can she address this before her court date, which is more than 6 months out? Or what could the next step be for her?
Absolutely. And I think we had a similar question earlier where We went over the advantages of actually trying to resolve the matter before you even get to a hearing. All of this time that you have is a blessing. It's time to either negotiate. It's time. Let's just say you get an offer, but you can't afford it, but you could afford it in a couple of months. You might be able to buy yourself more time to actually afford a settlement during that time. And yes, if you get it resolved prior to the date of the hearing next April, you might not even have to go to court, and you don't have to take time off of work or time off of whatever you're doing. So absolutely, don't just assume that you have to wait until April. I would encourage you to be proactive and try to see if you can get this matter resolved, um, well before you ever have to go to court.
Love it. And yeah, I would echo that. Like, you can settle before court in some cases. That's going to be where you have the most leverage, is negotiating outside of the court setting, trying to address it, and offer to pay even a percentage of the debt. Like with the example we heard from earlier with Corey, he was able to settle for almost 50% of his debt. Now, that's not always going to be the case. In fact, Mitchell, I'm curious, in your experience, for people who owe a legitimate debt, maybe life circumstances made it hard for them to keep up with their payments, but the debt is real, it's owed, it's valid. In your experience, what kind of settlement percentage do you think is most likely?
Oh, that is very, very tough.
I know there
There
are so many factors that
there
affect the
are.
question, but I guess, like, in your experience, what would you say?
It is very difficult to say. I don't want to give a range because it varies immensely. It varies with the same creditor even month to month, in year to year. How it works is, let's just say you're being sued by Discover Bank, and Discover Bank has retained a law firm to sue you. Discover Bank is going to tell their attorneys, in the month of July of 2026, I want you to take no less than X amount for an actual settlement. And then the law firm, depending on their structure that they have with the creditor, they're going to say, okay, we're just going to take that amount because you're paying our bill. Or maybe they took it on contingency and say, okay, we'll take that amount, plus we're going to build ourselves another 5 to 10% so we can get paid too, as the lawyers representing Discover Bank. And so there's just so many factors to consider, and things that you'll never know about. Is the attorney suing you on contingency, or are they being paid hourly by the bank that's retaining them? Are there legitimate defenses to the lawsuit that the creditor's aware of that you might not be aware of? Hopefully not. And then what stage in the litigation are you? Are you on the eve of trial? Are you on the eve of a motion for summary judgment hearing? Is there another hearing that's coming up? Is it the fourth pretrial conference that's been reset a number of times, and the lawyer's just like, all right, I don't want to do this anymore. What can you afford? And we're willing to work with you or do whatever we have to do. What kind of leverage do you have in negotiations? Are you just on SSI? Are you just on disability income? Have you shared that with the creditor, so the creditor knows that even if they win the judgment against you, they're really not going to collect much, because you can't take blood from a stone. You have nothing to give them. All of these things are going to come into play. It's very, very hard to generalize a percentage or even a range for each creditor and each law firm that you might encounter when you're being sued by a debt collector.
Yeah, I think it is tricky, and a lot of it has to do with, like, your financial hardship and the position that you're in, how much you can realistically afford. But yeah, thank you for sharing some insights on that. I think we've got time for maybe one more question. How are you doing with time, Mitchell?
I could do one more question, and then if it's okay, I just wanted to make some closing comments
Yes.
before we get out of here.
Yes, we would love that. Okay, we'll do one more question, and then we'll give some time to Mitchell. So this question comes from Alethea in Georgia. Alethea says, I'm about $30,000 in debt. I got behind after my divorce, but I believe I was a victim of identity theft. I think my ex-husband or his girlfriend ran it up. Any thoughts or tips, Mitchell?
Yes. So, unfortunately, this is becoming more and more common throughout the years. It might not be always your ex-husband or his girlfriend. It might be a stranger that you're not even aware of. One of the first steps I always ask consumers to take if they ever suspect that there might be identity theft or fraud at stake, and that is, go to the police. You need to go out to the police and file a report with your police department that will detail why you think there's identity theft, what happened, what is the effect of the identity theft, what accounts have you identified that might actually have be the result of identity theft, and that at least gives you a start that you could, if you needed to, take to court or show somebody else at an arbitration that this is actually not my debt, this belongs to somebody else. Look, I even filed a police report. It gives your claim a little more sense of authenticity. You also want to consider filing a affidavit. There are affidavits you could find online. The Federal Trade Commission, the FTC, has an identity theft affidavit that I recommend people go and fill out as well. That's something else, another document that you could use to defend yourself in litigation or arbitration or later on, showing that you legitimately feel that this is identity theft. And then another step I would ask everyone to take is I want you all to go and pull your credit report. A lot of people do not know if they have one identity theft account, there might be other accounts out there as well that you're not aware of that are also have been opened your name, or credit that has imploded on accounts that you've already had open, depending on the circumstances. So just to get a handle on where your financial health is in general, but also when you're dealing with these types of issues, go to annualcreditreport.com. It's a website that you can get every single year, free credit reports from all three major bureaus. Pull those reports, go through the trade lines on your credit report, and make sure everything looks familiar and you know where everything is. That's a great, again, as a separate note, great step to take if you're trying to take control of your financial health, but especially when you're dealing with a fraud or identity theft issue. It's the best way to do triage and identify what exactly is happening, what exactly has happened, and what might be happening in the future. So those are some preliminary steps I would definitely take. And if you ever get summoned to court on a debt that you believe is the product of identity theft, you want to let the court know, you want to let the attorney for the creditor know. Sometimes creditors will have their own affidavit that they want you to fill out and submit back to them so they can do a preliminary investigation themselves internally to see, does this claim have any merit? And nevertheless, if you were able to show through a police report and an affidavit that you've taken steps a reasonable person would take if they happen to find themselves in a situation, you might be able to prevail. It's never a guarantee, but it is something that you can at least try to defend yourself with, especially if these debts are not valid.
Love it. Well, I think just for the sake of time, I'll start to wrap things up. But Mitchell, I wanted to say huge thank you for coming on the Debt Hotline tonight and sharing your expertise, your thoughts. I think your answers were very insightful, very educational. So thank you so much. And I did want to say, just make a quick announcement that right now Solo is actually hosting a giveaway. So if you go over to solosuit.com/giveaway, we are hosting a debt payoff giveaway in which we're rewarding someone $4,700 to help them pay off their debt. $4,700 is the average amount that people are sued for that use Solo to respond. So based off of more than 300,000 users, again, $4,700 is that average amount that people owe, and we wanted to give back and help someone pay that off. So you can enter, it's free, there's no strings attached. All you have to do is just submit your name at solosuit.com/giveaway, and we're running that until the end of September. The giveaway is officially called the Dancing in September Debt Payoff Giveaway. So go ahead and check that out. And if you've been sued for debt, you can use Solo to respond to the lawsuit. You can also use our online negotiation platform called Solo Settle to negotiate with creditors and collectors alike and settle your debts outside of the court process and kind of digitalize the whole thing. So those are some great resources for anyone who is dealing with a debt lawsuit. And Guardian Litigation Group is also a wonderful resource. With that being said, I'll give some time, Mitchell, to you for your closing remarks.
Thank you so much, Hannah. And again, I really appreciate the opportunity to be here on the Debt Hotline. I really enjoy what Solo is able to do to help consumers around the country. I understand that hiring an attorney sometimes seems like a very expensive and daunting task, and an entity like Solo is able to really empower people and give them options if retaining an attorney is not something that they would like to do, can afford, or are comfortable doing. I wanted to just remind everyone, I believe this was said at the beginning, that everything we went over this evening, although I am an attorney, this was just for informational purposes only. This is not to be considered legal advice. I would always recommend, if you find yourself in any sort of situation, that you still attempt to speak with an attorney or retain an attorney. I also would like to add that on that subject, attorneys today, you may not be able to afford to have them represent you in every stage of the litigation. Sometimes you could use solo to help draft something, but still consult with an attorney, whether that's negotiated for a fee or not. A lot of attorneys are willing to at least hear you out and tell you what they're able to do or not able to do for you, and you could sort of dictate or negotiate the terms of representation. But unbundled legal services has become more common today. A couple of reminders that I have for everyone out there that might be dealing with a debt lawsuit and things we've gone over already. Make sure that your communications are in writing. It's very, very important. If you negotiated something, if you said something, if they said something to you, it's one thing to tell a judge that. It's another thing to be able to show the judge that. Should it ever come to that, or an arbitrator as well as settlement agreements. If you ever get a settlement agreement, make sure before you start making any payments to them over the phone, get it in writing first. These collectors, they're professionals. They know what they're doing. You get on the phone, you'll get a deal that sounds great, but they need a payment right now. Like if you're going to miss out on this opportunity, I need you to make a payment right now to keep this deal locked in, or else we're going to have to do something else at a later time. You want it in writing first. You always want it in writing. It's very, very important. It's not very difficult for them to produce a settlement letter. They do thousands and thousands of them a day, but you do not want to make any payments until you actually have the settlement agreement in writing first. You also you don't want to ignore any notices from the court. That was the thing we started with this evening. But it goes without saying, if you don't show up to court, the creditor is going to win the case via a default judgment, and it completely changes all of the opportunities you have to potentially assert any defenses you have available to yourself. Like I said earlier, I've had clients that didn't show up to court 2 years later. Creditors trying to garnish their wages or execute the judgment, and they're saying, oh, it was fraud, it was identity theft, or I paid this debt, this number wasn't right. And unfortunately, it might be too late to assert those defenses. So always remember, if the court papers say be there on a certain date and time, that you are there on that date and you are there 15 minutes early. You want to make sure you do not miss those proceedings. And then, as Hannah said, I'm an attorney. I work at Guardian Litigation Group. I have the pleasure of supervising the litigation practice group at the firm. I supervise over 26 attorneys around the country that specialize in debt collection lawsuits. We are always here to help consumers in any way that we can. Our website is guardianlit.com if you ever want to check us out. I hope I could do this again sometime, Hannah. This is a lot of fun. I really do enjoy being able to speak directly with consumers that have questions on these issues. But again, I appreciate the opportunity to be here this evening.
Yeah, well, thank you, Mitchell. We loved having you. We would love to have you again to answer more questions. Hopefully, for everyone listening, hopefully the information we shared tonight was helpful. If you have more questions, you can always call in to the Debt Hotline at 801-613-8181. We answer questions live twice a week, and it's part of our podcast. So we just want to help educate people, and like I said before, point people in the right direction. So thank you so much, Mitchell. It was great to have you.